My Lords, there have been a number of reports into the use of investigatory powers by public agencies in the UK, and indeed I published my own report which looked at the Metropolitan Police's use of undercover police at the Regulation of Investigatory Powers Act and at police databases. And I found that the police had overreached and misused their powers, aided by illiberal legislation that is not fit for purpose, and, of course, a mayor who was happy to turn a blind eye rather than champion civil liberties. Today I'll limit my comments to David Anderson's report, and like many noble lords, I welcome several of the recommendations in there. I'm pleased he found that RIPA is not fit for purpose and should be replaced. This is something that the Green Party called for at the last election, and we had it in our manifesto. It has failed. It fails to regulate the actions of undercover police officers, it fails to support the confidentiality of journalistic sources, and it fails to protect legal privilege. And it certainly doesn't provide a proper and open right of redress via the Investigatory Powers Tribunal. I'm pleased too that Mr Anderson recommends that the new legal framework, which replaces it, should comply with international human rights standards. I find this particularly relevant at a time when the government is indicating it would consider withdrawing from the European Convention on Human Rights. And I would welcome clarification from the government on the implications of this new legal framework if we were to leave the ECHR. I also welcome the recommendations for judicial approval for the interception of communications rather than the current arrangement of a Secretary of State. In practice, ministers are not held to account for warrants because it's an offence to disclose that a warrant has been granted, and the government's policy of neither confirm nor deny it becomes enacted on security matters. Were questions to be asked here or in the other place about the specifics of an intelligence operation, they would not be answered. When questions of security are asked, the common response is operational issues and the stonewalling of NCND. It's in part this lack of accountability why I welcome the move to judicial approval. I also think the idea of replacing the 3 existing oversight commissioners with a single independent surveillance and intelligence commissioner is one to be welcomed. I believe it would provide greater safeguards around the use of metadata and also provide increased safeguards which are needed for lawyers and journalists and others who handle privileged information. By contrast, there are some aspects of the report which I do feel do not go far enough and cause me concern. For example, I'm pleased that Mr Anderson recognised that the role and jurisdiction of the IPT should be expanded. However, I do not think his report goes far enough. I do not believe the IPT should hold proceedings behind closed doors. Instead, cases should be brought into open court, subject to closed material procedure or public interest immunity framework. This would provide greater transparency and allow for secrecy where necessary. I question the bulk collection of external communications, those sent from and into the UK. While Mr Anderson says that they should continue subject to additional safeguards, I should like to see a far more robust case put forward from the police and security services, which makes clear why blanket non-targeted surveillance is more effective than targeted operation-led powers. I found the information provided in the 6 agency case studies in the report to be limited. I remain to be convinced that the results achieved could not have been achieved using targeted surveillance. I'm pleased too that Mr Anderson states that no operational case has been made for requiring service providers to retain records of users' interactions with the internet, so-called weblogs, as proposed by the Draft Communications Data Bill, better known as the Snoopers Charter. I'm pleased he has questioned the lawfulness, intrusiveness and cost of the proposals. His report also points out that no other EU or Commonwealth country requires the blanket retention of weblogs, and in fact Australia has recently prohibited this in law. I hope the Government and the Home Secretary will pause for reflection as to why we alone need such a power. The report touches on the use too of undercover state agents or covert human intelligence sources. I accept this was not the focus of his report, but it's an area where I have huge concerns. The House is probably aware of the case of several women who are deceived into long-term, intimate sexual relationships with undercover police officers. Their testimony to the Home Affairs Select Committee laid bare the life-changing consequences these women suffered. I'm concerned that as it currently stands, RIPA still authorises sexual relationships by state agents. I find this quite alarming. If Parliament thinks state agents should have this power, which I don't, or whether there should be limitations to this power, it must be part of the debate that we're having. If RIPA is to be replaced, then its replacement must clarify the law in this area. I should also like to draw the House's attention to a particular aspect of RIPA which I find inconsistent and also in need of reform. Different forms of intrusive surveillance are authorised at different levels. For example, interception of communication requires authorisation from the Secretary of State. On the other hand, the authorisation of direct surveillance, including the activities of an undercover police officer, require only the authorisation of another police officer. And it's worth pointing out at this stage that most of the investigatory powers used to obtain communications data are done so by the police and not the security services. I believe that the highly intrusive nature of an intimate relationship with a state agent presenting as someone else is capable of being far more intrusive than the interception of communications. I should therefore like to see judicial authorisation for undercover state agents. In conclusion, I hope that this report leads to a proper debate on these issues, but in order to have a rational and proper debate, we must stop describing the threat we face as unprecedented. It is, as Mr. Anderson explains, a surprisingly common mistake. As someone who's had a file held on a police database of a domestic extremist, I'm concerned by systems of surveillance which are not clearly defined, targeted and publicly held to account. The past few years have seen revelations that GCHQ spied on Amnesty International, undercover police have been sent to spy on those campaigning for police accountability, and RIPA has been used to violate lawyer-client privilege. It's really time that we had a proper debate. I think that there should be clear rules and processes around obtaining data. And it shouldn't be easy for the state to obtain communication. That's the cost of privacy in a free society. It's our role to challenge the police and security services to provide a proper case, supported by evidence, for any additional powers that they need or request to do their job. And those who challenge the police and the security services don't do so because we're unaware of the threat that we face. We do so to protect the very values that terrorism seeks to undermine.